I want to thank you. I want to welcome Leah Cameron. She is with CDF Labor Law, and she's going to chat with us today about the 2023 labor laws that are ahead of us. Leah's been a long time affiliate partner with us and has hosted many SIOM programs. So we're happy to have you back today. She's also been a partner with CDF for 12 years. And in addition to her litigation practice, she really values the proactive approach in counseling, in risk management and litigation avoidance, and keeping her clients abreast of all the new laws to stay compliant. So we're excited to have Leah here with us. From our team, we also have Dana McCauley. She's the director of auctions and experiential marketing. And I believe Ashley's with us. She is our trade relations and international programs manager. So I'm going to turn it over to manager. Yeah, I'm going to turn it over to Leah and let you know that the program is being recorded today so that we can post it to our SIOM page. So thank you, Leah.
Thanks, Tracy. Okay, I'm going to, fingers crossed, share my screen with you all. Can you all see my screen there now?
We can.
Yes. Okay, great. Yay, success. Okay, so thank you for that introduction, Tracy. I have been, I've just always really enjoyed working with Sonoma County Vintners and doing these presentations for members. It's been rewarding and fun to get to know folks. So, you know, I just want to say at the outset, like, if you have any questions after this presentation, please feel free to reach out to me. I think my contact info should be here in the slide deck. Anyway, thank you for being here. Let's see. Okay, can I control my slides? Okay. So there's my contact information in the slide. If you would like to contact me afterwards, if you have any specific questions about the materials here today or any other materials or any of the other issues, you know, employment related issues that you might have. I specialize in employer defense. I do, as Tracy said, I do litigation, representing employers in lawsuits and various agency hearings. And I also do advice and counseling. So especially a lot of my smaller winery clients will have advice questions for me, you know, to help them navigate a problematic performance issue with an employee, to help them navigate a high risk termination, to help them draft legally compliant policies. That's a lot of the stuff that I do for a lot of my smaller clients. And then, you know, unfortunately, sometimes clients get involved in litigation and I have to defend them in those lawsuits. I also do a lot of class action work for some of our bigger clients, a lot of tech clients. And that's a little bit about what I do. My firm, CDF, all we do is employer defense. So we specialize in that work. We have 5 offices located across the state. I am in our San Francisco office, but I live in Sonoma County. I live in Petaluma. And ever since the pandemic, I've been working a lot from Petaluma too, although I am in our San Francisco office today. Okay, so just some housekeeping stuff. If you are looking for, you know, like HR or MCLE certification, we can provide that to you. Just reach out either to Dorothy, her email is there in this slide, or you can reach out to me after the training and we'll make sure to get you one of those certificates if you need one. So we also emailed out, Tracy should have emailed out the slide deck so that you have a record and you can write notes and keep the information that I'm sharing here today. If you did not receive it or you would like a copy, obviously you can reach out to Tracy. You can also reach out to me or Dorothy at CDF. This is supposed to be a 60-minute training. I'm going to try to see if we can get through it by 11 o'clock, but we'll see since we got started a little bit late. If you have questions as we're going through, since this is a nice small group please feel free to add your questions into the chat. I would say don't do the Q&A because I'm not using that function, but if you put your question in the chat, I will try to monitor and I will answer if I think it seems like a question that would be helpful for the whole group to discuss. If not, if I don't get to it, I will try to email you after with a response. Okay, the last housekeeping issue is that we do regular webinars like this through our firm and our blog. And so if you're interested in receiving notices about all of the webinars that we do throughout the year, you can sign up at the link provided to get on our mailing list. We do blog posts and webinars so that you can stay up to date with all of, we pretty much cover everything of note related to California employment law as it occurs and pretty quickly. So you can stay up to date that way if you like. Okay, so we're going to talk at the beginning of this training about new legislation that has gone into effect in the last year. And most of it is, it was passed last year, but it was effective as of January 1st of this year. So new legislation affecting employers for 2023. A few things related to COVID-19 regulation, although there's less of that, thankfully, than we had in previous years. And then we have some key judicial decisions from 2022 that will affect employers in 2023. And then finally, a few other miscellaneous areas of concern. So let's start with new California and federal legislation that took effect as of January 1 of 2023, unless I tell you otherwise. Okay, the first important piece of legislation is the new expanded pay data reporting and pay transparency rules. For most of you who are smaller employers, the pay data reporting might not apply to you, but the pay transparency rules almost certainly will. So previously we did have a pay transparency rule in California, but those rules are now significantly expanded as of 2023. So in 2022, job applicants could request pay scale information for the positions that they were applying for. But this new law now obligates all employers to provide pay scale information to any current employee about the pay scale for the position that they currently hold. And this rule applies to employers of any size, no matter how many employees you have. If you have a current employee who asks to know the pay scale for their position, you have to provide that. Pay scale means the range from here to here. What is the top and bottom of the range for their salary or their hourly rate for the position that they hold? You don't have to provide, this doesn't include commissions or bonuses or anything like that. It's just the base salary or hourly rate that they are earning. In addition, any employer with 15 or more employees is required to provide, just affirmatively provide it right up front in the job posting, the salary or hourly wage range for all positions that are being posted. So that means, if you put some job posting up on a website, you have to include in that job post the pay range, the top to the bottom amount that you're anticipating offering for that position. In addition, the same bill, SB 1162, also created additional pay data reporting requirements. So what does that mean? Under existing California law, private employers with 100 or more employees have already been required to submit an annual EEO-1 form to the Federal Equal Employment Opportunity Commission. And they were also required under previous law to provide the California Civil Rights Department with similar reporting. It used to be called the California Department of Fair Employment and Housing, or the DFEH, but it's now called the California Civil Rights Department. And you used to have to provide them with an annual report by March of every year, but that law has now changed and been expanded in 2023. So it used to be that employers could satisfy this California requirement by submitting their federal EEO form to the Civil Rights Department, just submit the same report to both entities, but now you have to do a separate report for the California requirement. Any private employer with 100 or more employees has to submit pay data to the CRD by the second Wednesday of May. So it's not March anymore for California. The federal EEO requirement is still March. None of that has changed. But the California report has to be submitted to the CRD by May 10th of 2023. And you can't just submit your EEO report. You have to submit a second report. The type of information that you have to provide is expanded. So you used to only have to provide the number of employees that you have by race, ethnicity, and sex, but now you have to also provide the median and mean hourly rates of pay for each of those groups. And you used to have to, if you had multiple establishments, you had to provide a report for each establishment and then a consolidated report. You no longer have to provide the consolidated report, but you still have to provide the report for each establishment. Now, here's where a lot of you who are smaller employers might be implicated by this. So in addition to, if you have 100 employees at your business personally, if you have 100 or more employees hired through a labor contractor within the previous 12 months, you have to submit an additional pay data report covering those workers as well. So maybe your business, your winery only has a handful of employees, but you use over 100 employers or 100 employees in the last 12 months through a labor contractor, through a farm labor contractor, you are probably falling now within this rule. And so you have to provide this pay data report to the CRD with information regarding those contracted workers. Even if you don't consider them your employees, the statute specifically calls out employees of labor contractors, and you have to submit the report indicating this information for people who were employed through the labor contractor. A labor contractor is defined as any individual or entity that supplies, either without or with a contract, to the client workers to perform labor within the client's usual course of business. So what that means is, let's say you use like an outside vendor who provides janitorial services for your winery. I don't think you need to consider those folks or that labor contractor. But if you're a winery and you hire a labor contractor, or you contract with a labor contractor to provide harvest workers in the farm, out in the field, then those would be within arguably the scope of your business. And you are going to have to consider those people in your head count in determining whether you need to submit this form. The labor contractors are required by this statute to assist you with filing this report by providing you all of the information that you need. So they're supposed to provide you, all the underlying data that you need to submit this report. They're required by law to do so, but you should make sure that your labor contractors understand this, maybe make it a contractual term of your arrangement with them so that you can be assured that they're going to be providing you this information when the time comes so that you can comply. Okay, so we spent a lot of time on that one because that's an important one, I think, particularly on the labor contractor side. There are penalty provisions for failure to comply. So just be aware that that's there, and that the CRD may be coming after employers who do not comply. So I would suggest, erring on the side of compliance with both the pay transparency and the pay data reporting pieces. In addition, this Senate bill creates new record keeping requirements for private employers. You now have to keep the job title and wage rate history for each employee for the duration of their entire employment plus 3 years thereafter. This is longer than a lot of other record keeping requirements. You may only keep records for 3 or 4 years. You need to keep at least the job title and pay wage rate information for the person's entire tenure of employment. And failure to maintain those records creates a rebuttable presumption in favor of the employee if there's ever a dispute or a complaint by the employee. So where I see this potentially being an issue is if you use like a external HRIS software and you like switch vendors and you lose data when you do the switch, that's going to be a problem for you. So if you're rolling over your HR software, you want to make sure that that job title and wage history information is retained and transported over to the new system. Okay, our next law that we're going to talk about is HR 4445. This is not too new, but it's a big change. So I'd like to highlight it here again. This is an amendment to the Federal Arbitration Act. This is a federal law that prohibits any mandatory arbitration of employee claims of sexual harassment or sexual assault. So if you have an arbitration agreement for your employees and it says that all employment law claims are to be arbitrated, including sexual harassment claims, the employee can opt out of that sexual harassment claim provision. So they can say, I know I signed that arbitration agreement, but I want to be able to sue in court, and they're allowed to opt out of that. So you don't necessarily need to go back and like revise your arbitration agreement if you have one. It doesn't, the fact that your arbitration agreement might be overbroad does not invalidate the arbitration agreement. It just means that the employee could opt out of that sexual harassment provision if they wanted to sue your company for sexual harassment in court versus arbitration. On the other hand, I will say there have been a lot of changes to arbitration agreement laws in the last few years. And so if you have an arbitration agreement that's a couple years old, it might be worth taking a second look at that, having an employment attorney take a look at it and help you make sure that your provisions are up to date, because as we'll discuss later in this presentation, there have been multiple changes to arbitration law. Okay, and yeah, it just says right here on the slide that this law is not retroactive. So if somebody has like an older sexual harassment claim prior to March of 2022, then it would not be subject to this law. Mandatory bereavement leave. We've not had a bereavement leave law in a while, but we have one now. So any full-time or part-time employee of an employer with 5 or more employees who's been working for at least 30 days is entitled to, they have a right to 5 days of bereavement leave for the death of any qualified relative. He doesn't have to be paid. You don't have to pay them for their leave time, but you have to provide them with at least 5 days off for bereavement leave for any of the qualified or specified individuals. Interestingly, parent-in-law is on the list, but son or daughter-in-law is not. I don't know how they came up with this list, but it is what it is. Not to say that you can't have a more generous policy, right? But this is the baseline policy that you at least have to have at this point. If you already have a policy to pay bereavement leave, then that's great. You can continue to have that, but that's not required by this particular statute. You can require the employee to provide documentation of the death to verify it. And there's no limit of times that an employee can use this annually. So if there are multiple family deaths in a year, they get 5 days off for each one. Some interesting wrinkles on this law are that you, as the employer, have to maintain the confidentiality of the employee taking the leave. So I would suggest treating it similar to a medical leave. So, you know, you don't tell when an employee is out on a medical leave, you don't go around telling everyone, oh, they're having, you know, and explain to everybody what kind of private surgery they're having, right? You just say they're on leave. Similarly, you're not allowed under this law to tell other employees why they're out. So it's a little odd because you might think, well, you know, people want to express condolences and be supportive, but under this law, as the employer, you can't tell the other employees why they're out on leave. You just say they're out on leave. Obviously, the employees can voluntarily share that information, but as management, you can't be disseminating that confidential information. The leave can be taken for any reason. So if you see on Facebook that they went to a resort in Mexico during their bereavement leave, you know, think hard before you discipline them for that, because, you know, maybe they're probably just going to come back and tell you, well, I needed to get away from it all. That's how I dealt with my grief, right? So they get the 5 days, and I would, you know, not recommend questioning their conduct during those 5 days. The leave can be intermittent, can be taken anytime within 3 months of the death. And there is an exemption for collective bargaining, but it is a pretty tight exemption. And I don't think many of you have unionized workforces, but that's just a note there just in case. Okay. Next is an extension and expansion of family leave and kin care leave to non-relatives. So if you don't already know, in California, you can use your family leave or your kin care leave. You can use half of your sick leave to care for for your kin under California law. That's what kin care leave is. And then you all probably know what family leave is, right? You can get your CFRA or FEMLA family leave. So in California now, this is expanded, not to just family, but to family plus any designated person. Now, a designated person, it's not just for kin anymore. You can designate any person, blood or not blood relation, whose association is equivalent to a family relationship. This is totally undefined as to what is equivalent to a family relationship. So could it be a roommate, a best friend? I don't know. The law is not clear, and someone may request leave to care for a designated person, and you may doubt the familial nature of the relationship. But do you really want to be the first person to challenge the familial relationship of an employee to their designated person? It's a very nebulous law, and I would be very cautious about denying kin care leave to someone if they can demonstrate any kind of family-like relationship. And to make it more challenging for the employer, the designated person can be identified by the employee at the time that they request the leave. However, they can only designate one person a year. So once they've said, I'm going to take time off to take care of my friend, and they designate that person, they can't have multiple friends that they take time off for in the year. It's just that one person, or any family, like actual family members. That, they can take time off for as many of those as they need to, of course, limited to the amount of kin care that they're entitled to under law. And as I said at the beginning, a lot of clients don't track the amount of sick leave or FEMLA or CFRA that's taken for a family member versus for the person themselves, right? Because I said you can take up to half of your sick leave to care for kin, and the other half is reserved for you. A lot of employers don't track that because it's hard to track it. So they just say you can use up to all of your sick leave to care for yourself or another family member, right? And so that would just now need to be extended to this one additional designated person. Okay, we have another law now aimed at prohibiting discrimination based on reproductive health decisions. This is a law that was enacted by the California legislature in response to the Dobbs decision. If you don't know what the Dobbs decision is, it's the Supreme Court case Dobbs versus Jackson. It's the abortion decision that overturned Roe v. Wade last summer. In response to that US Supreme Court decision, the California legislature has expanded FEHA, the Fair Employment and Housing Act, to include a new protected class of person. Under FEHA, there are all these protected classes, your race, age, gender, religion, various other categories. Now we have a new class of protected person, which is someone who has made a reproductive health decision. I think the intent of this law was to protect anyone who is choosing to have an abortion, that they can't be discriminated against by their employer for doing that. But it does apply more broadly to any kind of reproductive health service. So that could be, or reproductive health decision. So that could be the choice to have many children, or the choice not to use birth control, or the choice to use birth control, or any other health, reproductive health related decision. Okay, now an additional protection for employees that the legislature passed this year is protection for employees who refuse to come to work due to an emergency condition. This is really nebulous. It's going to be very interesting to see how a lot of these cases or these laws are interpreted. And there's probably going to be a lot of litigation out there, which keeps employment attorneys in business. So maybe the plaintiff's bar or the employment bar was behind some of these rules. I don't know. Anyway, so California employers are now prohibited from taking any kind of adverse action against an employee who refuses to come to work or who leaves work due to a unsafe condition at the work site, or because they had a reasonable belief that there was an unsafe condition at the work site. What is an emergency condition that allows the employee to walk off the job site or refuse to come in? Pretty much any disaster-related condition, any evacuation order related to the work site or the employee's child's school. Interestingly, it does not include a health pandemic. So this would not justify an employee refusing to come into work for fear of COVID-19. But it could potentially, I think, of particular importance to most of you folks, it could include a fear of coming to work due to imminent wildfire. Now, how imminent or dangerous does the situation have to be for them to be justified in not coming in? I don't know. We do not know. There are some exceptions to this rule, but it's mostly for, employees who are like first responders, disaster service workers, or other employees who are required by law to provide assistance in an emergency. I didn't see any exemptions that look like they would apply to employees who are being asked to stay to protect company property, like to move wine. So what does this mean? This doesn't mean that you can't ask employees to help move wine if there's an imminent wildfire, but it does mean that if they walk off the job or refuse to come in, and there is a real threat of a disaster or emergency, then you can't retaliate them or take adverse action against them, discipline them for not coming in. I realize this puts a lot of businesses in a hard position if they need to have employees help them protect the company's assets, but this is the law. It's also not clear to me, if there's the emergency condition includes a situation of peril to the safety of persons or properties. So does that mean that if there's a condition that is threatening the property but isn't threatening to humans, that they can still leave the work site? I don't know. It looks like they may be able to. Okay, next, protection for employees who use cannabis outside of the workplace. So this actually goes in effect next year, but it expands that Fair Employment and Housing Act again to prohibit employers with 5 or more employees from discriminating against an employee because they use cannabis away from work or they fail a drug test because they have indications of cannabis in their system, because as most of you probably know, it is difficult to determine if someone is under the influence of marijuana in the workplace, right? Because the indicators under current testing methods will still show that marijuana in your system for a long time after the intoxicating effects has subsided. So somebody could be using marijuana at home and then come into work and they're no longer under the influence, but they would still test positive. So you can't retaliate against someone or discipline someone for failing that drug test and having that marijuana in their system. You can still prohibit an employee from being under the influence of marijuana at work, but you're going to have a really hard time proving it. The burden is now on the employer to prove that the employee was in fact under the influence at work. And I know there's efforts to develop testing that could help establish that, but I think at this point you just have to rely on objective symptoms of observed behavior of the employee in the workplace. There are some exemptions for certain employees in safety sensitive positions. So if you have a drug screening policy or marijuana use policy, now is a good time to review it. Okay, legislative changes related to COVID-19. COVID supplemental paid sick leave has expired. It expired on December 31st. However, if you had an employee who was on COVID leave before New Year's and it continued into New Year's, they could continue out that COVID paid sick leave into the new year. And the Labor Commissioner has said that they are planning on enforcing COVID pay sick leave violations from last year. So they'll still be enforcing and pursuing complaints for violations that occurred last year. And so your employees, if you didn't pay somebody properly last year for their COVID leave, they could still request back pay for that time. You do still have some notification requirements related to COVID-19 exposures. But for this year, 2023, you no longer have to send everyone an individual written notice if they had a close contact. You just have to post the notice. The content of the notice is generally the same, but you can post it instead of sending it out to each employee. You also don't have to provide notice to the local public health agency of outbreaks currently, but this COVID stuff is always changing, so keep a close eye. The work posting, you should post it wherever you put all of your other work postings. If you have like the wage and hour posting somewhere near your break room, that's where it should go. It needs to be posted within 1 day of the the notice of the exposure. It has to provide the dates, the applicable dates and location of exposure, and the other information listed here on this slide. If you have a workforce that speaks something other than English, you should post the notice in English as well as that language. Okay, this slide just provides a link if you want more information about the current COVID exposure notification requirements. Okay, key judicial decisions affecting employers. The first one is Viking River Cruises. This is probably the most impactful employment law of the year, and it has created a lot of questions about employment arbitration agreements, particularly as it relates to PAGA litigation. So to set up the context for you a little bit, in 2014, there was a California Supreme Court decision called Iskanian that carved out PAGA claims from arbitration agreements, so you could not require your employees to arbitrate PAGA claims. What is a PAGA claim? It's a Private Attorney General Act claim where your employee stands in the shoe of the state to enforce the state's labor laws. In practice, it means that one employee can file a claim based on any wage and hour law violation against their employer and purport to represent the entirety of the employer's workforce. It's a representative claim, but there are not a lot of procedural protections or safeguards, unlike a class action. So it makes it really easy for plaintiffs' attorneys to pursue these types of claims, and has led to an influx of many, so many PAGA cases over the last few years being filed. These PAGA cases are very expensive and difficult to defend and resolve. So PAGA litigation has been very popular amongst the plaintiffs' bar. But this Viking River Cruises decision from the US Supreme Court has really threatened to break down that paradigm, which is helpful for employers. It said that the Supreme Court holding in Viking River says that an arbitration agreement can require arbitration of an employee's individual PAGA claim. What happens to the representative portion of the PAGA claim is unclear. The US Supreme Court said that the majority opinion said that they thought that the representative portion of the claim should be dismissed, but Justice Sotomayor disagreed and said she thought that was an issue of California law. And the California Supreme Court may agree because they've granted review of a case called Adolph versus Uber Technologies to address the fate of the representative component of the PAGA claim. So what happens to the representative component, it remains to be seen, but it is binding law now that employees who wish to pursue a PAGA claim, their arbitration agreement, if they've signed one, would apply to the individual component. So the employer can compel them to arbitrate their individual component. So employers, if you happen to have a pending PAGA litigation that you're defending, which is probably not the case unless you're one of our larger employers, but you can potentially enforce the arbitration agreement now against the PAGA claim. But for any of you who have arbitration agreements, what you ought to do is revisit that arbitration agreement and see if there's any language that you need to change regarding class action waivers or representative action waivers insofar as it might affect the arbitrability of PAGA claims. Okay. Just another update about AB 51. This is a law that Governor Newsom signed into law back in 2019 that prohibits employers from mandating arbitration as a condition of employment. So saying you can't force your employees to sign an arbitration agreement as a condition of employment. That law was supposed to go into effect in 2020. The U.S. Chamber of Commerce successfully enjoined that law from going into effect. So it was not allowed to go into effect while the issue was pending in front of the courts. The Ninth Circuit then in 2021 overturned parts of that injunction. So it looked like the law was going to go into effect. However, now the Ninth Circuit has pulled that opinion. So the injunction is now in effect. Bottom line is that this law has never gone into effect. It's still pending whether it can go forward. But if you do have an arbitration agreement that mandates arbitration as a condition of employment, you can still get away with it for now, but you should monitor the status of this case in case that changes. Okay, a couple more cases. Johnson versus Winco Foods affirmed that Winco was not obligated to compensate an applicant for their time spent traveling to and taking a pre-employment applicant drug test. So this is actually a good, helpful decision for employers. It just reinforces that California employers do not have to compensate applicants for pre-employment activities, such as time spent in interviews, time spent in physical examinations, time spent getting a drug test. You don't have to pay applicants for that time. Naranjo versus Spectrum Security Services. This is a decision that held that meal and rest break premiums constitute wages and must be reported on wage statements as a separate line item. Otherwise, you can be subject to penalties for failing to do so. So the California courts have gone back and forth on whether these meal and rest break premium payments constitute wages or penalties. Just to step back a little, hopefully you all know that if your employees are not able to take a meal or a rest break as permitted by California law, you are required to pay them a premium penalty for each instance when they're not provided that break. Now, this case says that that penalty has to be included on the wage statement and it has to be a separate line item on that wage statement. So compliance tips are maintain a strict meal and rest period policy, promptly pay out meal and rest period premiums when they're owed, properly identify and calculate premiums and indicate them on the wage statement, and inform all of your managers and payroll of the potential need to reformat your wage statements to ensure that they adequately reflect this. Now, because a lot of times I will see, especially with a smaller employer, that maybe they'll just add an hour of pay to the wage statement. So now instead of it looking like the employee worked 25 hours, it'll just say like wages, regular 26 hours. That is not correct. You should have a separate line item that has the 25 hours of regular pay and then the 1 hour of indicating the premium payment. And you also want to make sure you're calculating that premium payment correctly because it has to be calculated at the regular rate, which is the rate that you use for overtime calculations, not the base rate. Carr versus Foster Farms. This is a decision that essentially found that a holding from a workers' comp appeal board hearing does not necessarily apply, or it's not determinative of the outcome of a separate disability lawsuit. So that's because the issues before the workers' comp appeal board are narrower than the issues that would be in front of the court on a FEHA claim for disability discrimination. So just because if you get a good finding from the workers' comp appeal board that there wasn't any discrimination by the employer in the workers' comp forum, that outcome is not necessarily going to govern the outcome of a separate lawsuit that the employee might choose to bring for disability discrimination. Mita versus AutoZone. This is a suitable seating case. If you don't know, the California wage orders require that all employers provide suitable seats to employees when the nature of the work reasonably permits the use of seats. So in this case, though, the employer did provide seats, but they didn't provide it in the workstation. They had the chairs provided, they were sitting in the manager's office, and the employees could come and ask for a seat and take it to their workstation if they needed it. But there was a question about whether or not that was sufficient under the law, because the employees testified that they didn't know the seats were available, they didn't feel comfortable asking the manager. So all that to say, it's not that you can't necessarily keep the seats like in another location, but you do, if that's how you do it, you need to put it in your policy, you need to disseminate the policy, you need to train employees to make them aware that these seats are available, they are entitled to use them if their work reasonably permits it. Cadena versus Customer Connex. This is a federal case that has to do with boot up time for your computer. And the federal court said that boot up time could be compensable time under federal law. This doesn't, it's just a good reminder because in California, this is generally the law already. So in California, California law doesn't recognize the de minimis doctrine, which is the idea that minimal amounts of time need not be compensated. Every minute of work under California law generally needs to be compensated. So if it takes your employees 5 minutes to boot up, I would recommend that you add, some employers just add 5 minutes to every shift just to compensate for that boot up time that it takes them to get their computer on before they can log in and start the time clock, right? This opinion, though, was limited to the fact that the boot up of the computer was part and parcel with and indispensable to the employee performing their work activities. So the court didn't opine on whether shutdown time was compensable because that wasn't necessarily integral and indispensable to the employees performing the work. However, I would say under California law, that boot down time is probably compensable as well. So you want to make sure you don't have any chunks of time that your employees are getting ready to work or leaving work that is not being compensated. Okay, this is a rounding case, Camp versus Home Depot, that said that even if, let me back up and say, we have generally thought that any kind of facially neutral rounding policy, let's say you say, okay, well, if you start at 8, if you come in 5 minutes before, 5 minutes after, it's just the time clock's going to round to 8 o'clock. And it's facially neutral because it can go to the benefit of the employee or the benefit of the employer, right? So typically we had thought that that was lawful, but this new case calls that into question because it said that a facially neutral rounding policy that in the aggregate favored employees was still unlawful because the particular employee at issue was in the aggregate underpaid by the rounding policy. So it does look like it was essential to the court's analysis that Home Depot's timekeeping system in this instant was capable of recording time to the minute. If you had a system that was not capable of recording time to the minute, then you might not be subject to this, this new holding. But I think the upshot of all of this is that if you have a system that is capable of recording time to the minute, you should revisit any rounding policy, and it is likely advisable to just be paying people their actual hours or their actual minutes worked and not utilize rounding. Okay, some non-employment cases with impact. The Dobbs versus Jackson Women's Health decision, which is that abortion decision that I mentioned. This is not an employment law decision, but it is having some kind of interesting impact on employees. Or employers. So the EEOC has actually received quite a few complaints and is pursuing them, investigating them against employers who are actually providing benefits to employees to receive abortions. So you may have seen, various employers are considering providing benefits to their employees to pay for their travel, to travel out of state to receive an abortion. or to come to California to receive an abortion. There's just lots of benefits policies going into effect now to try to support they want to support their employees who are receiving abortion. But these EEOC complaints are complaints by employees who are not seeking abortions, who are saying that they're being discriminated against because they're not seeking an abortion and they're not receiving similar benefits. So just all that to say, if you're considering some kind of benefit to employees in the wake of Dobbs versus Jackson, just think carefully about potential unintended consequences of doing so. Finally, the UNC and Harvard affirmative action cases. These cases are challenging affirmative action plans at these universities that use race as a factor in admissions. The U.S. Supreme Court is predicted to find in favor of the plaintiffs in some manner, restricting or prohibiting race as a factor in school affirmative action plans. And if that happens, then I would expect that we see similar challenges to company diversity programs. So if you have any kind of diversity program that actively seeks out applicants and hires on the basis of race, then you should follow this closely, because that may be potentially, subject to legal challenge if these cases go the way that we think they will. Okay, we were almost to the end of my content, which is just really incredible because we started a little bit late, but I'm just going to blow through a couple more issues here, which is other concerns for employers in 2023. The first is that the minimum wage goes up, and you may remember that previously there was like a different rate for a smaller employee versus a smaller employer versus a larger employer. Everybody now, the minimum wage for all employers, regardless of size, is now $15.50. One implication that people sometimes forget about is that the salary exemption test changes as a function of the minimum wage. So to be salaried exempt under California law, you need to be paid twice the minimum wage, which when the minimum wage goes up, that means now the salary exemption test requires you make at least $64,480 a year, $5,373 a month. If you have people on salary making below that amount, you either need to bump them up to this minimum, or you have to pay them on an hourly basis. You cannot have a salaried worker earning less than $64,000 a year anymore. Okay. Just real quick, most of you probably don't deal with unionization, but you should be aware that this is the most pro-union climate that we've seen since Roosevelt. I wasn't around under Roosevelt, but that's what I hear. Union petitions are up 53%. Union elections are up quite a bit. Starbucks is a great example. They're an employer generally known to have great benefits and treat employees well, and yet they are facing unionization on many, many fronts. So in addition, we're predicting recession, layoffs are expected, and so that just tends to push more unionization. And in addition to unionization, there are separate efforts to create these union-like governing boards for specific sectors. One has just been passed for the fast food industry. So it's something just to be on the lookout for as an industry, seeing what is coming down the pipeline. There's this push for even non-unionized industries to be governed by these union-like boards. So it's something for your lobbyists that you may work with to be on the lookout for. Okay, so that is all of my content for today. We've reached the end of our time. Are there any burning questions that anyone would like to share before we hop off? Feel free to email me after the presentation. My email was at the beginning of the slide deck, but just to say it again for you, it's lcameron@cdflaborlaw.com.
Excellent. Thanks, Leah, for all that information. Lots going on in 2023, and I hope everybody found this informative as I did. Any questions for Leah? I do have one question. Will you tell me a little bit more about the premium rate for the lunchtime and mealtime? Is that an overtime rate?
Yeah, it's not the overtime rate, but it's the regular rate. So in California law, you'll see the base rate and the regular rate. So someone's base rate may be $16 an hour, but you have to factor in things like bonuses, or there's various other forms of compensation that then have to be factored into the regular rate, to calculate the overtime. So essentially, like if someone earns a bonus, a non-discretionary bonus, then their hourly rate for purposes of calculating overtime is higher. So if they earn $16 an hour, but they got a $500 bonus, you average that out over all of their hours worked. Now they're earning, it looks like, it's like $18 an hour. You have to pay them overtime on the regular rate. So you'd have to pay them 18 plus 9, right? $27 an hour instead of 16 plus 8, right? $24 an hour. So that regular rate issue applies to meal and rest break premiums as well. So you would need to pay the premium on the regular rate, not the base rate.
Excellent. Thanks for clarifying. I know
Yeah.
that many wineries have a challenge in fitting in those appropriate meal times. And so that was good information.
Yeah, and I will say that regular rate calculation is fraught with error. So that's something I help clients with a lot. It's worth making sure you're getting your overtime rate calculation correct, because it opens you up to a lot of wage and hour litigation if you get it wrong, because it's an issue that affects the entire workforce. If you're calculating something wrong, you're calculating it wrong probably for everybody. And that is really good fodder for a class action or a PAGA action, which is really an expensive liability to defend. So you want to make sure you get it right.
It was also
Thank you.
really interesting to hear or to think about when the hourly rate minimum goes up, it impacts salary and non-salaried employees, like how they're classified. So that was
Yeah.
a great call out.
Yeah, I see from Susan, overtime hours has to include bonus. Yeah, that's right. That's right. You have to include you have to include the bonus when you calculate the rate that you use to pay overtime. Any
Excellent.
other comments on that? Okay.
Thank you, Leah, for your time. And if anyone has questions, you have her information.
Oh, we have
And
one more
Oh.
question since we started a little late. We'll go ahead and keep going for
Sure.
a minute or two. So
Yeah. What about commission? Okay, so that's a really good question. I think it has to be included. But I will look into that and let you guys know. I can provide a follow-up correspondence on that because I think you do have to include it. But I have to admit, I'm not entirely sure. So I will look into it. Tribute commission would be different. Right. Yeah, it's going to be different for each person. Right. It gets very complicated. Yep.
So folks can reach out to you if they have some additional questions.
Yes.
Yeah. Well, we really appreciate you being here today and all of this
Thank
time.
you.
Yeah. And
you.
you know what? I'm just looking here. Commissions are included. And I think I'm trying to think of what other pieces you guys might have of compensation. If you have like piece rates, if anybody gets paid a piece rate, I don't know if anybody's paid on piece rate, but that would need to be factored in as well. Okay, I think that's it. Yes, that's right. Sick pay has to be paid at the regular rate. Great. Exactly.
Okay, so with that, I'll stop the recording and